Goodyear Dunlop Tires Operations, S.A. vs. Brown, 2011. Supreme Court of the United States. Court. This case was decided in the Supreme Court of the United States in 2011. Issue. The issue for this case was whether or not the North Carolina trial court had general jurisdiction over an out-of-state defendant that is not registered to operate a business in the forum state. Facts. Here are the facts for this case. While on a bus in Paris, France, 2 passengers were fatally injured in an accident. They were 13-year-old soccer players from North Carolina, and their parents sued for wrongful death in North Carolina State's court against the defendant, Goodyear Dunlop Tires Organization, due to their relationship with involved subsidiaries from Europe who were also listed as defendants. Goodyear Dunlop Tires Organization was incorporated in the state of Ohio and had no place of business, employees, or accounts in the forum state. Additionally, the failed tire that was considered the cause of the accident was not distributed from the forum state, which is why they moved to dismiss the claims against them for want of personal jurisdiction. However, the defendants' attempts to dismiss the claims were denied by North Carolina trial court, and their ruling was affirmed by the North Carolina Court of Appeals. The justification given was that the defendants' tires were introduced from the forum state's stream of commerce as part of an organized process of distribution, with no attempt made by the defendant to prevent their products from reaching the forum state. From the court's perspective, this met the minimum contacts required to exercise general jurisdiction over the defendant, and would avoid causing hardship to the plaintiff that would otherwise arise if they attempted to file in another state. In response, the defendant appealed to the Supreme Court of the United States. Holding. The Supreme Court of the United States asserted that the conditions for specific jurisdiction were met by the plaintiff, but not for general jurisdiction, citing International Shoe Company v. Washington in their reasoning. They cited other cases to demonstrate appropriate uses of general jurisdiction for out-of-state corporations, which further illustrated the plaintiff's lack of appropriate reasoning for exercising general jurisdiction over Goodyear Dunlop Tires operations. Additionally, the Supreme Court of the United States did not consider the defendant to be, quote, at home, unquote, in the forum state, and would not hold their subsidiaries as a consolidated entity for the purpose of this trial. Hence, they reversed the North Carolina trial court and appellate court, granting the defendant's original motion to dismiss. Rule to remember. An out-of-state corporation's products being sold in a forum state can only meet the criteria for specific jurisdiction. General jurisdiction requires more sufficient minimum contacts, which is why it is rarely exercised on out-of-state corporations.